Are you preparing for the SQE and need a quick introduction to the civil litigation environment in England and Wales? You have come to the right place. This podcast presents the key components of the civil litigation rules and talks about pre-trial and trial process in the English courts. The presentation has been prepared by Dr. Ioannis and is read out by AI voices. Get in touch with Ioannis using the information in the description of this video for information on how it was put together. Let's get started then. We start with the fundamental aspects and key components of the civil litigation process in England and Wales. The presentation offers some background to the evolution of the civil procedure rules and outlines the key aspects of the court process and the civil litigation environment. The podcast also presents the structure of civil procedure in England and Wales. What do we mean by civil litigation? Legal systems operate based on a series of key dichotomies. The best known are the divisions between international and national law, public and private law, criminal and civil law. Individuals and corporations in their daily operations within the country in which they are based are concerned with national laws, the effects of contractual relations, and the impacts of their activities in private law, and get to defend and enforce their rights through civil courts. Civil litigation, therefore, is the part of the court process that involves resolving disputes between private individuals and corporations who are seeking to assert and enforce their legal rights against each other. When someone brings a claim in a civil trial, they usually aim to obtain compensation for pecuniary and often tangible losses that have been caused by the respondent, the person on the other side of the suit. Courts, of course, also deal with the other aspects of law that we mentioned above. Administrative courts are there to ensure that government authorities and state-related bodies operate within the confines of the law. When an individual complains that the state is not abiding by the rules, for instance, will bring an action for judicial review of a public body decision before such a court. The remedy will come through reversing the decision of a public authority and, in cases of additional violations perpetrated by the authority, through compensation to the individual. Criminal courts are there to ensure that individuals obey the law, both through punishing violators and through explaining the law and setting examples for future actions. Although court systems, including those involved in civil and criminal justice systems, have some deterrent effect, however, the main purpose in the case of civil justice is redress, whereas in criminal justice, the main purpose is punishment. Courts are not the only systems through which one may seek redress or adjudicate disputes. International tribunals and, like international investment tribunals, are separate, supranational systems that deal with resolving disputes between states and foreign investors. International tribunals like the International Criminal Court, ICC, investigate and try individuals charged with the major human rights violations, like war crimes. On the private side of dispute resolution, one also finds a vast array of privately run alternative dispute resolution (ADR) systems, like mediation, negotiation, conciliation, and arbitration, especially international commercial arbitration, tasked with facilitating efficient dispute settlement in commerce and trade. In a civil case, a person who has suffered the wrong, usually referred to as the claimant, in older case law you will find the word plaintiff, will initiate proceedings against the defendant or respondent. In a civil context, claimants can be individuals, corporations, or even public bodies. The responsibility for proving the case, otherwise known as the burden of proof, rests on the person who initiates the action. In civil proceedings, the claimant must prove their allegation and substantiate any claims for compensation. For example, in the context of a breach of contract action, the claimant will need to establish the existence of the contract, substantiate the breach, and provide evidence to demonstrate losses suffered as a consequence of the breach. In civil cases, the claimant must prove the case on a balance of probabilities. This is known as the standard of proof, which means that it is more likely than not that the defendant is liable. You can compare this with the standard in criminal trials, where the prosecution must prove the case against the defendant beyond reasonable doubt. Unlike what you see in movies, in civil cases, most decisions will be made by judges or magistrates and only rarely by a jury. For example, according to the County Courts Act 1984, juries participate in civil trials only where they involve libel or slander, false imprisonment, malicious prosecution, or fraud. If the court finds the respondent responsible for the civil wrong alleged, they will be liable to provide the remedy awarded by the court to the claimant. This will usually be in the form of financial compensation, an injunction, or declaration. Very rarely will courts issue injunctions that mandate personal performance of some action, as we see, for example, in the case of orders of specific performance as a remedy for breach of contract. This is because an order for a personal action is usually considered too restrictive of personal liberty, and an award of damages is preferred in almost all cases. Remember that a civil wrong is not prohibited in the same way that the criminal law prescribes certain activities. One can choose to breach a contract, so long as they are willing to compensate the victim of the breach and make good whatever damages they are suffering. By contrast, one cannot choose to assault another, even if they promise to pay for their hospital bills, suffering, and inconvenience. Every civil justice system aims at the efficient resolution of disputes involving legal rights, entitlements, and responsibilities. It achieves such resolution through a network of adjudicative and dispute resolution processes when the parties in question have failed to reach a settlement of their dispute through direct discussions, or through the network of ADR mechanisms that help keep most civil claims away from courts. While ADR works effectively to resolve the problems of willing participants, the courts are great at reaching conclusions in disputes with recalcitrant participants, or in cases where the future relations between the parties are already compromised beyond repair. A court can compel an unwilling respondent to engage with the process and has the power to order them, if they are found liable for violating legal obligations, to offer compensation or other types of redress to satisfy the claimant, whether they agree and feel like it or not. It is important to remember that all types of final dispute resolution systems, we can include arbitration as one of these, alongside courts, require a power of enforcement outside the control of the parties involved. Courts do have such power and in the case of arbitration, can lend it to the tribunal to force certain outcomes. There are 5 fundamental and important principles of civil justice. 1. Advice and access, empowering the parties. 2. Conditions for sound decision-making. 3. An efficient process. 4. A fair process. 5. Upholding judgment. These principles derive from the Human Rights Act 1998, effective since October 2000, which makes the European Convention on Human Rights directly applicable in English courts. Article 6.1 of the Convention states that important codification of fundamental principle consists of the following elements. The rights to 1. A fair hearing. This is a wide concept embracing a. The right to be present at an adversarial hearing. b. The right to equality of arms. C. The right to fair presentation of the evidence. D. The right to cross-examine opponents' witnesses. And E. The right to a reasoned judgment. 2. A public hearing, including the right to a public pronouncement of judgment. 3. A hearing within a reasonable time. And 4. A hearing before an independent and impartial tribunal established by law. Despite recent discussions in the UK as to a perceived need to distance the legal system from the European Convention, civil disputes are resolved through a public court system which has a clear structure and defined processes mirroring requirements common across the European continent. Civil cases are generally dealt with in the county court and high court. You may have heard that the English court system relies on adversarial proceedings. This means that the parties are responsible for producing the evidence that backs up their claims and counterclaims. The court will consider such evidence leading to a determination by a judge through the process of formal hearing of the case in court. The judge makes the decision and leads the administrative aspects of the process, but is not in charge of investigating and bringing forth evidence. This is done by the parties. The process of dealing with a civil dispute through the civil courts is known as litigation, and the parties involved are referred to as litigants. Impressive as all this sounds, do remember, however, that it is only a fraction of disputes that make it to courts, with the vast majority of cases being settled at earlier stages, usually with the help of some ADR process. If all attempts to arrive at an amicable solution have failed, a civil court case will commence with the issue of proceedings, in which the claimant will set out their case and their demand, usually some form of monetary compensation. This is then sent to the defendant or respondent against whom the claim is being brought. If they dispute the claim or the facts, they can choose to respond with their defense. Once a defense has been received, the case will be managed by the court and assigned to an appropriate procedure. There are 3 available case management tracks. Following allocation to one of these tracks, the parties will complete the process of collecting their evidence and prepare for trial. This preparatory stage is usually undertaken by qualified lawyers, in the English context solicitors, who will identify the key facts that claimant seeks to prove and ensure that there are adequate evidence, documentary and otherwise, in support of those facts. If the case proceeds to trial, the litigants and their representatives will attend court to present evidence to the judge. After examining the evidence, the judge will give their decision and specify an appropriate remedy, which, as we mentioned earlier, will normally be monetary compensation known as damages. Civil litigation is governed by a set of procedural rules, the Civil Procedure Rules. The system currently in operation in England and Wales entered into force in the spring of 1999 with the Civil Procedure Rules, CPR, of 1998, SI 1998 No. 3132, and the associated practice directions and forms as supplementary rules. CPR 1998 was the product of a long process of legal reform characterized by dissatisfaction and frustration over the pre-existing system. Lawyers, litigants, the judiciary, and politicians were joined in anguish over a system. County Court Rules 1981, Rules of the Supreme Court 1965, that was expensive, complex, uncertain, and riddled with delays. The system that was introduced in 1999 hoped to change all that for the better and was the product of a long process of consultation, which started in 1994 with the appointment of Lord Wolfe to review the rules and procedures of the civil courts, aiming to improve access to justice, cut costs, reduce complexity, modernize terminology, remove unnecessary distinctions between practice and procedure, and bring under control a litigation process that seemed to have lost touch with its aims, the efficient and fair resolution of disputes. A properly functioning court system needs to balance the resources between rich and poor litigants and offers certainty over costs and timeframes. For this to happen, pre-trial and trial procedures need to be organized and predictable. Further, maintaining the adversarial tradition of the common law should not mean that the court itself loses control over the process of the trial. Imbalance of means is a very serious issue in civil trials. Consider, for instance, that one party instructs a top firm of solicitors, while the other can only afford to instruct a small firm. While both parties have made their selections, the outcome is unbalanced and may jeopardize the chances of a fair trial. In Maltese v. Lewis, 1999, was held that the court must ensure that a level playing field was achieved, and can help by allowing the smaller firm more time, or in the preparation of trial bundles, the court could direct that the larger firm prepared them. The court could ensure compliance with the overriding objective where the representatives could be said to be unequal. The court has power to prevent a party being unfairly required to pay excessive costs because the other party has instructed unreasonably expensive advisors. Issues, such as disparity of means, highlight the need for the rules to be set and enforced by the judge, and not be at the whim of the parties. These conclusions and aims form the basis of Lord Wolfe's report, the interim version of which, Access to Justice, interim report, was published in June 1995, with the final version published in 1996. A further review of the system was undertaken by Lord Justice Jackson, with the final report published in December 2009, and resulted in further extensive changes aimed at enhancing the court's powers to control the costs of litigation and permitting different methods of funding for civil cases. The litigation environment currently operates on the basis that the court does determine how each case should progress by making appropriate directions, setting strict timetables, and ensuring that the parties complied with them, backed up by a system of sanctions which the court could impose itself without the need for an application by any party. The overriding objective of the reforms is set out in Rule 1.1 of CPR 1998, which states, 1. These rules are a new procedural code with the overriding objective of enabling the court to deal with cases justly and at proportionate cost. 2. Dealing with a case justly and at proportionate cost includes, so far as is practicable, a. ensuring that the parties are on an equal footing, b. saving expense, c. dealing with the case in ways which are proportionate, 1. to the amount of money involved, 2. to the importance of the case, 3. to the complexity of the issues, and 4. to the financial position of each party, 5. ensuring that it is dealt with expeditiously and fairly, 6. allotting to it an appropriate share of the court's resources, while taking into account the need to allot resources to other cases, and 7. enforcing compliance with rules, practice directions and orders. This overriding objective must be borne in mind at all times when conducting civil litigation, both by the court, Rule 1.2, and by the parties and their legal advisors, Rule 1.3. The Civil Procedure Rules, CPR, are divided into parts, each one detailing the steps to be taken in proceedings, and supplemented by a practice direction. The ethos of civil litigation is, according to the overriding objective discussed earlier, to deal with cases justly, Rule 1.1. This necessitates that the speed of the trial is no longer determined by the parties, but managed by the court, Rule 1.4. Rule 1.4 states, 1. The court must further the overriding objective by actively managing cases. 2. Active case management includes a. Encouraging the parties to cooperate with each other in the conduct of the proceedings. B. Identifying the issues at an early stage. C. Deciding promptly which issues need full investigation and trial, and accordingly disposing summarily of the others. D. Deciding the order in which issues are to be resolved. E. Encouraging the parties to use an alternative dispute resolution procedure if the court considers that appropriate and facilitating the use of such procedure. F. Helping the parties to settle the whole or part of the case. G. Fixing timetables or otherwise controlling the progress of the case. H. Considering whether the likely benefits of taking a particular step justify the cost of taking it. I. Dealing with as many aspects of the case as it can on the same occasion. J. Dealing with the case without the parties needing to attend at court. K. Making use of technology. And L. Giving directions to ensure that the trial of a case proceeds quickly and efficiently. The process is characterized by a set of general principles that aim at achieving just results, ensure that the parties are treated fairly, costs are kept reasonable, and delays avoided. We will now look in turn at what we mean exactly when we mention justice and fairness. Justice is deemed to be achieved through the application of the principles of equality, regardless of the resources at the disposal of each party, economy and proportionality, meaning that costs are imposed only when necessary, and expedition. Fairness means that all litigants cooperate with each other and the court, with lack of cooperation being subject to penalties and cost sanctions, that each party has the opportunity to fully state their case, and that pre-litigation protocols assist the early provision of information in certain types of trials, e.g. in personal injury claims. Note, however, that the rules do not apply to all types of litigation, with some areas excluded, such as insolvency, family proceedings under the Mental Health Act 1983, and non-contentious probate matters. As noted earlier, in order to understand and interpret the rules correctly, it is necessary also to look at the practice directions which supplement the rules. In some cases, the practice direction for a particular rule will be more expansive than the rule itself, in an effort to provide context and practical advice in applying the rule correctly. A consequence of the reform that led to the current version of the rules is that litigation in England and Wales is now much closer to European norms, where it is common for courts to set the timetable, and where key issues of liability, quantum, and evidence are identified early on. There is also increased emphasis on reaching settlements rather than letting the court process reach its conclusion. Finally, it is important to note the modernization of the language of the court, in an effort to assist transparency and understanding of the process by those who do not have a legal background. Be mindful of the change in terms, as you will come across the old language in cases and texts that predate this process. For example, claimant replaces plaintiff. A writ is now a claim form. Pleadings are statements of case. Statements are now particulars of claim. Interlocutory has become interim. Interrogatories have become requests for information, and discovery is now disclosure. Similarly, leave of court is now known as permission. Infants and minors are called children, and in-camera sessions take place in private. The U.S. term subpoena is replaced by witness summons. There is also less use of Latin, with inter partes becoming on notice, and ex partes meaning without notice. We will now introduce the main players in the legal services field, present and explain the roles of solicitors, barristers, and other lawyers, and how they differ from each other. This allows the reader to position legal support appropriately within the process of considering potential claims and seeking redress. The presentation then explains the initial steps in commencing a claim and describes what a legal advisor would consider before commencing proceedings. We conclude with an overview of how a claim can be responded to. The legal profession in England and Wales has traditionally been separated to two branches: solicitors and barristers. Modern reforms, however, have opened the market for legal services both within established types of legal providers and through the introduction of new ones. For example, the Access to Justice Act of 1999 abolished barristers' monopoly of audience before the higher courts, and the Courts and Legal Services Act of 1990 abolished the monopolies that solicitors had over property conveyancing, probate work, and rights to conduct litigation. The Legal Services Act of 2007 further extended rights of audience of non-barristers before the senior courts. The latter act also allowed barristers to form partnerships with non-barristers and even non-lawyers in legal disciplinary practices, or LDPs. Solicitors are what best approximates lawyers in the continental and U.S. sense of the term, meaning they will usually be the first port of call for legal advice in issues of commerce or for personal claims. Solicitors can work independently in partnerships, often limited liability partnerships or LLPs, and in-house as legal advisors for corporations. As of September 2021, if one wishes to become a solicitor, they will need to sit and pass the Solicitor's Qualification Exam, or SQE, which is a similar process to sitting a bar exam in other jurisdictions and have qualifying work experience. The SQE replaces a prior system of qualification that was based on attaining a qualifying law degree, LLB or GDL, alongside a vocational course, LPC, followed by a training contract. Solicitors are represented by the Law Society and regulated by the Solicitors Regulation Authority, SRA. Barristers are lawyers specialized in arguing the client's case in court. Barristers are usually contracted by solicitors to assist in the preparation and presentation of a case in litigation. Most barristers work as self-employed and source their own work, but do this within chambers, who provide administrative support. It is possible, since reforms in 2004, that someone directly contracts the services of a barrister without going through solicitors, and barristers can also work in-house in companies as their solicitor colleagues. To qualify as a barrister, one needs a qualifying law degree, LLB or GDL, and to complete a vocational course, the BPTC, as well as an aptitude test before joining one of the four Inns of Court in London. Qualifying work follows. This is called a pupillage. Senior barristers are appointed by the Crown as Queen's Counsels. The Bar Council is the profession's representative body, with the Bar Standards Board being the independent regulator. One does not, however, need to be a solicitor or barrister in England to be involved in the provision of legal services broadly defined. One could become a chartered legal executive by undertaking training recognized by SILEX, the Chartered Institute of Legal Executives. A legal executive can undertake all work that can be done by a solicitor, but under the supervision of a principal. As of 2021, one can qualify as a SILEX lawyer. A new professional qualification, CPQ, will enable SILEX lawyers to qualify with practice rights in at least one specialist area of law, such as dispute resolution, criminal litigation, residential conveyancing, commercial conveyancing, employment law, business and commercial law, family litigation, wills, and probate or immigration law. We will now discuss the procedural steps required in bringing and defending a civil claim before a court in England. The first step will naturally be for the lawyer to meet with the client in order to take instructions and preliminary proof of evidence. This will be done by a solicitor in England and Wales, but here we use the generic term lawyer to reflect the diversity in the provision of legal services after the Legal Services Act 2007. It is important to note here that in the context of an adversarial system, the parties' legal representatives are responsible for investigating and collating the evidence to be presented at trial. Lawyers will also investigate how to raise money to unfund the case and will ensure that any claims fall within limitation periods, Limitation Act 1980. Lawyers will interview witnesses to gather evidence and collect and archive relevant documentation. They will also decide which evidence is useful and admissible. At this stage, there is no power to compel witness statements, so client representatives need to rely on the cooperation of others. Evidence gathering may at this stage involve visiting sites and commissioning the reports of experts. Once these preliminary steps are taken, the claimant's solicitors will need to consider whether they wish to appoint a barrister. At about the same time, the claimant's legal team will apply to the court for pre-action disclosure in order to gain information about the evidence available to the other side. Once the case is registered with the court, it will be allocated to a relevant track, and the parties will need to comply with relevant pre-action protocols. The aim of these is to encourage pre-trial settlement and to avoid the expense and delay of litigating the case. Specific pre-action protocols exist to facilitate communications between the parties and the court in the areas such as personal injury, clinical negligence, construction and engineering dispute, professional negligence, and defamation actions. Even in areas where the Ministry of Justice has not established pre-action protocols, parties are expected to behave as if one was in place and cooperate with each other. Parties that are not cooperating can face penalties by the court for their failure to comply with the spirit of the pre-action code of conduct. The first step in preparing a civil case for a lawyer representing a claimant is to identify their objectives. It is important to identify as early as possible what the client seeks to achieve by pursuing a claim. There could be legal and non-legal objectives, including, for example, monetary compensation, an admission of fault, or the opportunity to voice a complaint in a public forum. The job of the lawyer will be to offer a preliminary assessment as to whether compensation is obtainable for the alleged wrong and to investigate ways of obtaining adequate redress through a different route. For example, a customer who received defective goods may have the option of returning for a refund other than suing for damages, depending on whether they have suffered losses in addition to the difference in value between what they ordered and what they received. There may also be technical bars to obtaining redress through the courts, such as exceeded time limits for causes of action that are in the past. Also, the claimant should be advised on potential reputational and relational impacts stemming from pursuing litigation. Such actions can damage the relations of parties with multiple or long-standing business connections and prove detrimental beyond any amounts in compensation and costs associated with a particular event. After these initial issues are addressed and the claimant confirms their intention to proceed with the case, the key task for their lawyer will be to collect relevant evidence to support and substantiate their claim. This is a time-critical issue, as the availability of evidence, witnesses, and their willingness to cooperate usually decreases with time. At the same time, it is important to solidify who the potential counterparties are, and whether they have the financial means to satisfy compensation claims, if the aim of the action is to obtain monetary compensation. The rule is that all persons relevant to the case must be included at the same time in the same action. Morris v. Wentworth Stanley, 1999. There is little point, however, suing a nearly insolvent corporate for compensation they will not be paying in any case. This is significant, not only for practical purposes of evidence gathering, but also because of issues of professional conduct may arise, in case, for instance, of a conflict of interest for the lawyers themselves. Finally, part of the lawyer's job is to provide the client with an estimate of costs and verify that the client is capable of meeting legal costs or help arrange for financial support or external litigation funding. Every potential litigant must consider not only their own legal costs but also potential exposure to the other side's costs. Traditionally, other than insuring against such costs, there was little that could be done to minimize a litigant's exposure. Because of modern reforms to legal services, however, there are now various options available to a litigant to help reduce cost risks. These options include conditional fee agreements, damages-based agreements, after-the-event insurance, and third-party funding. These can be used separately or in conjunction with each other. A further key avenue in keeping costs and delays at bay is to consider methods of resolving the dispute other than litigation. The entire array of ADR mechanisms should be discussed with the claimant in consideration of whether they could offer an adequate way forward. In certain cases, and some of the pre-action protocols too discussed below, active case management by the court will involve consideration of ADR as a necessary precondition to proceeding with litigation. Whilst the practice direction and approved protocols will not be prescriptive on how or when ADR should be utilized, the parties must give serious consideration to using any suitable form of dispute resolution before resorting to litigation. Once appropriate discussions have taken place with the claimant, claimant, and the lawyers have engaged in the tasks described above, especially collecting sufficient evidence to substantiate a realistic claim, the claimant's representatives will send to the proposed respondent a letter detailing the claim. The information containing in this standard letter before claim, as it is known, will depend on whether the nature of the dispute places the claim within an approved protocol. In such case, the information to be included in this standard letter will be specified in the protocol. In any event, sufficient information must be provided to the other side so that the prospective respondent can investigate and gather evidence at their end, as well as arrive at a broad valuation of the claim and begin to formulate a response. The prospective claimant should also at this stage offer proposals for resolving the dispute via ADR. On the respondent side, protocols and the practice direction on pre-action conduct that you can find on the Ministry of Justice website here will offer guidance on what to include in the letter of response. Commonly, the respondent will acknowledge receipt of the letter of claim and, after some time to investigate the matter, will offer a declaration as to whether they accept or contest liability and the reasons for contesting it. In cases where primary liability is admitted, but there is an allegation of mitigating reasons, such as contributory negligence, is alleged, the letter should explain the impact it has on the claim and the calculation of its value. At this stage again, ADR as a suitable alternative ought to be considered, and the claimant will have the opportunity to respond to any mitigation or counterclaim before issuing proceedings in court. Failing settlement or successful conclusion of an ADR process, selecting the appropriate court for starting proceedings will depend on the financial value of the claim. The CPR splits litigation to 3 distinct tracks. Claims of a value below £10,000 will go to the small claims track, unless they involve personal injury or tenant and landlord disputes, for which the limit is £1,000, and disputed allegations of dishonesty. Claims exceeding £10,000 and up to £25,000 are usually allocated to the fast track. While legal representation is not required or common at the small claims track, parties will usually be assisted by qualified lawyers on the fast track. Claims exceeding £25,000 in value are usually allocated to the multi-track, and this can be issued in the county court or the high court. Cases with values exceeding £100,000, £50,000 for personal injury claims, will be handled by the high court, where all claims are placed on the multi-track. The action commences by sending a claim form and paying a fee. The form will contain the details of the action, or these can be submitted in a separate document as particulars of claim. These particulars must contain a concise statement of the facts on which the claimant relies. On receiving these particulars, the respondent must file an acknowledgement of service or file a defense. The judge will then allocate the case to its appropriate management track according to the CPR. In all management tracks, the court will tightly control costs and have a say on the type and volume of evidence that each party brings. Where expert evidence is needed, there is an expectation that a single joint expert should be used by the parties. There is also an expectation that the trial will be conducted within 1 day, which in practice means 5 working hours. The court will offer directions to the parties as to the steps that must be taken to prepare for trial involving a defined and strict timetable as to when each step must be taken. Organization is simpler on the small claims track and in the fast track process as directions are without a hearing. In multi-track cases, however, it is usual for the parties to meet with a judge to conduct case management conferences to prepare for trial and address preliminary issues. The most common case management directions are those involving documentary evidence. They will either necessitate standard disclosure, whereby each party lists evidence that they intend to rely on, or which are detrimental to their case, or alternatively, where witness and expert evidence is required, directions will provide for the exchange of evidence before trial. Under all tracks, parties will be informed of the trial date, or will alternatively be provided with a period of time when the trial will occur. It is at this stage, in addition to court-ordered case management, that the parties can apply to the court for any specific orders that they may require. These include an order to mandate that the other side performs an action they have missed, or take a required step in accordance with the timetable. Failure to comply with such orders can lead to the dismissal of the case with prejudice to the party at fault. The difference between the experience of trial on the small claims track and others, fast and multi-track, is that process in small claims track is informal and conducted at the discretion of the judge. Formal rules of evidence will only apply on the other tracks. In terms of costs, the judge will decide if any party should pay the other's costs and the amounts after the parties must provide a detailed breakdown of their costs. The general rule is the loser pays the winner's costs. On all tracks, it is possible to appeal all or part of the trial judge's decisions. The court will also set a date by which amounts awarded and costs are to be paid. The court has the power to enforce its judgment if payments are not forthcoming and timely. Court officials can attend a debtor's premises and remove assets that are then sold at public auction, with the proceeds going to satisfy pending amounts. Of course, a party that has entered insolvency may not be able to satisfy awards in full or at all. This is why assessing the viability of a claim in terms of the financial veracity of the respondent is an essential element of early discussions between potential claimants and their legal advisors. Every time someone approaches a lawyer to seek assistance with what they perceive to be a legal problem, it will be necessary to investigate whether there is a cause of action, meaning whether there is a legal basis to a potential claim. A cause of action could stem from voluntary relations between the parties, for example, contractual relations, business transactions, or trade activities, or involuntary acts, such as an accident, the commission of a tort, or some nuisance. The lawyer will need to sit with the potential claimant and carefully dissect the facts, discover, document, and secure any evidence, and offer an assessment as to whether the claimant's intended outcome, usually a claim of compensation, is achievable in law and probably in fact. After this initial assessment, the client will be able to make a decision as to whether to proceed with their complaint or action, and through which forum, for example, ADR or litigation. For example, imagine that Sonia approaches you for advice. She had booked a family holiday for the spring of 2020 involving flights from London and a week's accommodation and car rental for a total price of £3,000 with an online travel agent. Following pandemic-induced lockdowns and travel being banned at that time, Sonia and her family could not travel. Nonetheless, the travel agent has not offered a refund. If Sonia approaches you for advice, the first thing to do will be to assess the evidence that are available that will establish that there was a contract. As Sonia's case involves an online order, she would need to produce evidence of the booking, a booking reference number, a receipt of payment, and confirmation from her bank that payment has in fact been taken. As documentary evidence suffice, the initial process of evidence gathering will be straightforward, pretty much like collecting the information required to submit an insurance claim. In more complex cases, the legal advisor would need to assess the available evidence, especially if documentary evidence is unavailable or insufficient, as with the case with an oral agreement, and witness evidence need to be procured. If any entitlement to redress rests on legal basis that is not widely known, the legal advisor may need to research relevant legal provisions to update the potential claimant on the position in the law. In our case here, Sonia's entitlement as a consumer would derive from consumer protection legislation, both general and specific in relation to travel and distance selling. Once a legal entitlement is established, it will need to be verified that the loss has actually been suffered in the way presented. Were the dates of travel indeed falling within one of the lockdown periods where travel was against the law? Was the holiday canceled by the provider or the client? Were any communications detailing steps to take and where these followed? Once it is established that Sonia can prove that there was a breach which has resulted in recoverable losses, one needs to consider whether any additional costs and consequences were suffered that would allow the quantification of losses beyond a refund. What did the travel company do or fail to do, which amounts to a breach of the contract? Once the facts are established, the evidence secured, the legal position clarified, and the cause of action and entitlement identified, then the lawyer will need to consult with the client as to the best way forward. Are there avenues to obtain redress that do not involve suing the party in breach? Was the holiday insured by an industry body that can pay compensation when the provider fails to do so? Had Sonia obtained privately travel insurance that could cover the costs? Could Sonia benefit from some type of payment protection, for instance from her bank, that could compensate directly? If a third party cannot provide compensation or a refund, could Sonia complain to the company directly and escalate any missing refunds within the travel agency's own structure? Bringing such a complaint to a free service like a consumer ombudsman for this industry could be a cost-efficient way of pursing a claim. Are there other ADR methods that can be utilized? And do the terms and conditions of the travel contract provide for any? finally, is the travel agency still a going concern, or have they failed to refund or communicate appropriately because they have gone out of business? This is a real consideration in the particular context of this industry during the pandemic. These actions and processes will need to be considered well ahead of a decision to pursue a claim through the courts. And it is important to remember here that litigation is always the last option to be pursued when all else has failed. If the decision is made to proceed with litigation, Sonia will be heading to the small claims courts, where her breach of contract action will be allocated to an appropriate track and resolved in due time. As the facts are straightforward and the evidentiary basis concrete, Sonia would be able to pursue the action through the small claims process without needing legal representation. But she will need to be reminded of costs and time implications of pursuing her action through the courts. Civil proceedings will usually commence with the claimant's solicitors preparing an application using Form N1 or by using the new online service for claims below £10,000 in certain circumstances. In civil litigation, there are various prescribed forms of claim form, including Form N1 for claims issued under Civil Procedure Rule CPR Part 7, Form N208 for claims issued under CPR Part 8, Form N211 for claims under CPR Part 20. In addition, different forms are used for claims issued in the financial list, in the commercial court, and in relation to admiralty claims. Electronic claims through the Money Claim Service are issued in the County Court Business Center by sending the court service an e-claim form and paying the fee online. The particulars of claim must be included on the e-form. This is an efficient process for simple claims of low value and allows the court to process servicing quickly with the presumption that it has taken place on the 5th calendar day after issue. Respondents can also communicate electronically, and if this does not happen, then judgment can be entered in default by filing an electronic request. Through the traditional physical world route, after receiving the relevant form, the court will commence a process that stops the period for the statute of limitations and commences what is known as the period of service, lasting 4 months, as explained in more detail later in this section. The court will be deemed to have issued the claim when it seals it. The application forms will include the name and address of each party and a brief description of the nature of the claim and an indication of the remedies sought. Further, it will indicate the value of the claim to allow the court to allocate the case to the appropriate case management track. In some cases, the form should include a description of the source of the claim, especially if the case is heard in the High Court. The claimant is entitled to use the full limitation and the full validity period, 4 months, although waiting till the very end of a limitation period to file a claim may undermine the respondent's ability to respond effectively. It is important to note that from the point of service, the respondent will be on formal notification that legal proceedings have been actioned. Under the Civil Procedure Rules, a document setting out the case of the claimant and specifying the facts relied upon, called the Particulars of Claim, is either contained in the claim form or served on the respondent with the claim form, or within 14 days after service of the form. These particulars of claim set out the nature of the claimant's case, together with the remedy or relief sought from the respondent, and are the key document in allowing both the claimant's solicitors to articulate their case and the respondent in planning their reaction. Once completed, the form will be mailed to the court clerk's office by the claimant's solicitors with a cover letter requesting issuance, and the relevant fee will be submitted. This process is known as filing, meaning providing the court with documents. The court then assigns a claim number to the proceeding, and an issuance notice form containing a record of all case identification information regarding the claim is shared with representing solicitors. Most important documents which are used in litigation will need to be physically filed at court. Filing is possible electronically in some cases where a fee is not payable. During the pandemic, courts issued emergency orders to allow for electronic filing and virtual representation across the litigation system. We will now see in more detail what type of information needs to be included in the claim form and in a statement of case. Claimants must fill in the heading of the form to indicate the name of the court where they want the claim to be issued. Especially for money-only claims proceeding in the county court, and the claimant must state County Court Money Claim Center. The person being is called the defendant. In this guide, we use the term respondent to mean the same. Information needs to be entered to identify the claimant and the defendant and the capacity in which the suit is being pursued. In the brief details of claim, the claimant must offer a concise statement of the nature of the claim, specify the remedy they are seeking, e.g. payment of money or a specified amount. If the claim is not about a fixed amount of money, the value expected still needs to be identified to assist the court with allocating the case to the appropriate track, with the usual benchmarks being below £10,000, between £10,000 and £25,000 or more than £25,000. If it is not possible to put a value on the claim, this needs to be acknowledged. Other limits exist for specific types of claims. For instance, for personal injuries where specific wording is expected for claims up to £5,000 in addition to suffering of either less than £1,000 or more than £1,000 legal representation costs. In the particulars of a claim, which can be included in the form or submitted separately, the claimant must set out a concise statement of the facts on which they rely, a statement in case they are seeking aggravated damages or exemplary damages, details of any interest which they are claiming, and any other matters required for the relevant type of claim as set out in the relevant practice direction. Finally, a statement of truth must be signed by the claimant or solicitor. In cases where the claimant is a corporate entity, the claim must be signed by either the director or other officer of the company. We turn now to the issue of service of documents on a respondent in England and Wales. It is important to remember that it must take place within 4 months of the date of issue of the claim. This means that a claim form is strictly valid for 4 months and 1 day unless the defendant is served outside of the jurisdiction, which extends the time to 6 months from the point the form is issued. Documents will include the completed claim forms, for example Form N1, the particulars of claim, which may follow, and a response pack. This response pack will include acknowledgement of service, admission, defense, and counterclaim. This service is available in a variety of forms and will depend on the action being sought. Service will usually take place at the defendant's last known address, but the rules depend on the status of the defendant. Service is still deemed to have been effective even if the respondent was away at the time. The methods of service are outlined in Rule 6.31 CPR. They include personal service, post of the next day variety, see Rule 6.31, B, CPR and Dirie v. Bojaj 2020. Leaving the documents at the address for service, document exchange, DX, and electronic methods of service. Personal service means that documents are left with, or if that is not possible, in a close place accessible to, the respondent. Personal service to a company requires a person within a senior position to be served, CPR R.6.53b. Service can also take place using electronic methods. This is usually by fax or email, see Barton v. Wright Hassel LLP 2018, or if the respondents have made it clear in writing that this is an acceptable method of service, even by instant messaging, see Gray v. Hurley 2019. It is common for a contract to contain a term providing those proceedings can be served in a particular way, and sometimes, if there is mutual agreement, an ad hoc agreement on service will be effective, see Cranfield v. Bridgegrove Limited, 2003. Personal service on partners sued in the name of the partnership will be achieved by leaving the claim form with a partner. For companies, service can take place at their registered office. Service will generally be undertaken by the court with few exceptions, mainly for cases before the commercial court. If one of the prescribed methods of service has been followed, Rule 6.14 CPR deems documents to have been served on the day stated. If service cannot be made, for instance when the respondent is evading, then the claimant must seek the court's permission to use an alternative method in their future attempts. See Société Générale v. Goldas, 2017, providing written evidence with the reason why alternative service is sought and what steps have been taken to secure service up until that point. Alternatives could include a newspaper advertisement or service to another address which the defendant may frequent. See Abbey National plc v. Frost, 1999. In exceptional circumstances, service can be dispensed with under Rule 6.16 CPR. See Home Office v. Dorgan, 2003. After notice of proceedings has been served on a respondent-defendant, according to Rule 9.2 CPR, they can contest the case, fill in an acknowledgement of service alongside a defense, or acknowledge the claim. Part 9 responding to particulars of claim scope of this Part 9.1. 1. This part sets out how a defendant may respond to particulars of claim. 2. Where the defendant receives a claim form which states that particulars of claim are to follow, he need not respond to the claim until the particulars of claim have been served on him. Defense, admission, or acknowledgement of service. 9.2. When particulars of claim are served on a defendant, the defendant may a. File or serve an admission in accordance with Part 14, b. File a defense in accordance with Part 15, or do both if he admits only part of the claim, or C. File an acknowledgement of service in accordance with Part 10. Once a defense is filed, it becomes part of the case management system, and court will send the parties an allocation questionnaire so that the judge is able to allocate the case to the appropriate management track and provide directions as to how the case will proceed. A default judgment can be filed against a party that fails to respond, except in those cases involving Part 8 statutory claims and certain Part 7 claims, such as those relating to arbitration proceedings. A default judgment is won in favor of the claimant without the need to hold a trial. This is usually done in claims involving debt recovery where the response is either immediate payment or no response at all. While a respondent does not need to respond immediately to the particulars of claim if the form is not received, if they do arrive with the claim form, then they must fill in the correct admission form in the provided response pack. If they admit the whole claim, then they are advised to pay within 14 days. Paying swiftly has the benefit that it limits liability for the claimant's costs. There is, however, the option to apply to pay in installments depending on their personal finances, which need to be disclosed to the court. Alternatively, if the response is a denial, partial or full, of the claim, then they can benefit from 2 weeks to respond to the claim and another 2 weeks during which to file a defense, according to Rule 15.5 CPR. Consequently, there can be a period of 28 days between serving the claim and serving a defense. Finally, if the respondent wishes to contest the court's jurisdiction, they have 2 weeks in which to do so from acknowledging service, which can be extended at the discretion of the court. Civil proceedings that have commenced by ordinary claim forms will be followed by the exchange of statement of case by the claimant and/or the respondent. These statements are formal declarations specifying the position of each party in relation to the claims and inform the parties the case that will have to be met, define the issues which need to be decided, and provide the court with a concise statement of what the case content. Part 16 CPR offers information on the documents that constitute the statement of case, namely the claim form, the particulars of claim, the defense, any counterclaim, additional claims, reply to the defense, and any further information. The purpose of using statements of case at trial is to define the issues in a claim, and it will be a violation of process for the court to give judgment relying on issues which are not in the statement of case. For this reason, statements of case after the defense or counterclaim have been filed are unusual. The courts will actively manage cases to ensure that the civil litigation process meets its overriding objective. The overriding objective is defined in Rule 1.1 CPR as a procedural code aiming to enable the court to deal with cases justly and at proportionate cost. Dealing with a case justly and at proportionate cost includes, so far as is practicable, ensuring that the parties are on an equal footing and can participate fully in proceedings, and that parties and witnesses can give their best evidence while saving expense, dealing with the case in ways which are proportionate to the amount of money involved, to the importance of the case, to the complexity of the issues, and to the financial position of each party. This overriding objective must be borne in mind at all times when conducting civil litigation, both by the court, Rule 1.2, and by the parties and their legal advisors, Rule 1.3. The courts aim at ensuring that a case is dealt with expeditiously and fairly, allotting to it an appropriate share of the court's resources, while considering the need to allot resources to other cases, and enforcing compliance with rules, practice directions, and orders. In applying the overriding objective, the court must seek to give effect to its aims when it exercises any power given to it by the civil procedure rules or interprets any rule. Central to the process of managing litigation in compliance with the overriding objective is the track system of case management. Defended claims will be assigned to one of 3 tracks according to their monetary value and the complexity of the issues involved. The lowest value and simplest cases are normally allocated to the small claims track. For cases that are likely to be concluded within 1 day with a monetary value of £10,000 to £25,000 without complex issues to consider, there is a fast track. Cases that are deemed complex and are likely to take longer than a day or exceed £25,000 in value are likely to be allocated to a multi-track. The allocation to one of the tracks is made by a procedural judge after the filing of an allocation questionnaire, Rule 26.31, CPR, post the submission of defenses. There are specific time limits for the submission of these questionnaires, specifying at least 14 days after the date a defense was served on a party. The questionnaire enables the court to assess progress in the case and the possibilities of resolution, as well as the type of evidence likely to be needed for trial, its length and cost implications. Allocation questionnaires are not generally used in specialist cases automatically allocated to the multi-track, and there are special rules for certain types of cases. The small claims track. Claims with a value up to £10,000 will be allocated to the small claims track. To achieve time and cost efficiency, in this pathway expert testimony is usually not allowed, and requests for information will require permission of the court. Standard court directions will address issues around disclosure, notice of the hearing date, the length of the hearing, and evidence production. It is possible, with the agreement of the parties, that a small claim can be determined by the district judge on the basis of documentation without a hearing, Rule 27.10 CPR. If a final hearing is required, it will usually be dealt with by a county court district judge and conducted in the judge's chambers rather than in an open courtroom. The fast track. Most cases with a value between £10,000 and £25,000 will be allocated to the fast track. This track also takes care of non-monetary claims for injunctions, specific performance, and declarations. This is effectively designed as a halfway point for cases that do not require the complex consideration but are more significant in monetary value than those allocated to the small claims track. Fast track normally operates on a timetable offering a fixed trial date within 30 weeks of the track allocation. After allocation to the fast track, the court will provide case management directions and arrange a timetable for the process leading to trial. See Rules 28.22 and 28.3 CPR. These directions address disclosure of documents, service of witness statements, expert evidence, and timetables for trial. Parties are required to file pre-trial checklists by dates specified in the timetable provided. Multi-track. Cases valued more than £25,000 and those dealing with issues which are deemed particularly complex are allocated to a multi-track. Trial for these cases will usually take place at the Royal Courts of Justice, which includes all commercial list claims. Different forms are used in this track, and each case has a case memorandum and a case management bundle. Evidence production is more elaborate with more liberal use of expert witnesses. Time schedules and costs reflect the complexity of the issues under consideration. The overriding objective determines the practical aspects of the process of trial. A strive towards efficiency, in both time and cost, is immediately obvious in the way documentation is handled. At fast-track and multi-track trials, required documentation is arranged into trial bundles, which are then made available to the court and the parties for ease of reference. The assumption is that if everyone can consult the same document at the same time, the trial can progress much quicker and with less opportunity for misunderstandings and requests for further information. There is a time window for the claimant's solicitor to file the bundle, between 7 and 3 days prior to the start date of the trial. The contents of the trial bundle are standardized according to Practice Direction 32 CPR, which deals with process and production of evidence. When his case is heard at the Queen's Bench Division or Chancery Division of the High Court, the claimant is also expected to prepare a reading list for the assigned judge, alongside information on the time required to consider the documentation and to address it in hearing. A short, non-contentious summary of the issues in the case and of the relevant procedural matters to be considered is also prepared jointly by the parties' solicitors. In terms of presenting the relevant law, one should note that skeleton arguments and authorities are compulsory for high court trials and can also be requested in the county court. The principles of civil litigation derive from the Human Rights Act 1998, effective since October 2000, which makes the European Convention on Human Rights directly applicable in English courts. In terms of hearings, a public hearing is established as a right for parties under Article 6.1. ECHR private hearings are only offered when the case involves matters of national security or when it is necessary to protect a child or a patient. The court does have the power to order that the identity of parties or witnesses remain confidential. Section 12 and Schedule 2 of the Legal Services Act 2007 specifies who has rights of audience at trial. While the judge will aim for all issues arising to be dealt with at the same time, in cases where the complexity of the matter requires different treatment, it is possible to consider issues before or separately from the trial. Therefore, Three types of orders are open to the court: one ordering a trial of a preliminary issue on a point of law, a second set of proceedings on preliminary issues or questions of fact, and a third set on liability and quantum. These orders are usually issued at the allocation stage, but can happen later. A single judge will be responsible for hearing the majority of cases, unless they involve claims of deceit, malicious prosecution, and false imprisonment. Juries are not generally used in civil trials in England and Wales. Some exceptions exist for trials in the county court or the King's Bench Division of the High Court, although rarely is a request for jury trial accepted. Once the ruling is made, following Rule 40.71 CPR, it takes effect from the day it is given. The judgment of the court is first being pronounced, and it is then sealed and served. Note that a judgment is the final point of the court's determination, while an order is an interim decision. It is also worth noting that the parties can preempt a judgment by settling. The overriding objective is met by resolving the dispute. Therefore, settlement is the preferred way to address issues, instead of going to trial. If settlement is reached prior to hearing, then both parties have a responsibility to inform the court so that court time can be released. And there is the added benefit that all or part of the hearing fee can be refunded for timely notification, but the parties may still be subject to costs depending on how far the litigation process had progressed. Once a settlement is agreed and recorded, it can be enforced if either party fails to respect its terms. A settlement will be binding as a contract between the parties, even if it is not translated into a formal court order. The rules on how to deal with offers of settlement are contained in Part 36 CPR. An offer of settlement is treated without prejudice for the purposes of liability and remedies, but can be disclosed when the issue of costs is considered by the courts. To follow procedure, an offer must be made in writing, complying with certain formalities, and remains open for at least 21 days. If an offer is not accepted and the other party fails to achieve the offered result during trial, then they will be liable to the costs of the procedure. This is done to guide litigants towards settlement, rather than towards the expenditure of court resources. If the trial concludes with a judgment, it is likely that it will be for the immediate payment of a sum agreed as well as costs. Simple orders, such as payment orders, can be followed by enforcement proceedings on the day as they are entered. Under Section 98 Courts Act 2003, Registry Trust Limited is a non-profit entity and maintains a register of High Court and County Court money judgments. The register is open for inspection for a fee. Once the judgment is paid, a note on the register is made, which is significant in avoiding a mark on the debtor's credit record. Entries to the register have a lifespan of 6 years. A right to appeal exists in all systems governed by the rule of law. While the opportunity of appeal does not offer a second chance to losing parties, it is essential that it provides an avenue for errors to be corrected to safeguard the integrity of the administration of justice. Appeals in civil litigation are rare and restricted to safeguard the nature of judgments as final determinations of cases. Permission must be granted to a party to pursue an appeal, and it will only be granted where there is a realistic prospect of success. A notice to appeal must be filed within 21 days of the decision being appealed. There are also special rules for second appeals, which will rarely introduce fresh evidence. Appeals to the Supreme Court can only be made where the case raises is a point of law of general public importance. Legal representation in litigation will generate costs from when a solicitor is first consulted until their retainer has been terminated, after the enforcement of any judgment obtained. Beyond solicitors' fees, there may be counsel fees, experts' fees, the costs of the court, and various incidentals. Solicitor non-contentious costs will cover preliminary work involved in proceedings before trial, and the time spent on inquiries. Contentious costs are those incurred once the trial gets going, as they related to proceedings. See Rule 44.13 CPR. Parties are responsible for paying their own legal representation costs, but some of these costs can be recouped from the unsuccessful party. The crucial message to an unsuccessful litigant is that they will have to pay both their own representation costs and a substantial proportion of the other side's costs. Orders for costs are offered at the end of the trial, and at the end of any interim hearings and enforcement proceedings. At the end of a hearing, there will be a summary assessment of costs, referring to the statement of costs provided by the parties prior to proceedings. If such a cost assessment had not been provided, then the court can ask for a detailed assessment, allowing some time for the parties to produce that. A detailed assessment of costs will be done by a costs officer at an assessment hearing subsequently. District judges will perform these assessments in the county court, and the Supreme Court Costs Office will perform them in the High Court. Assessment of costs is made on two distinct bases, one being the standard basis, and the other the indemnity basis. The standard basis is the one usually applied in costs orders between the parties in litigation. The indemnity basis is used when a client is funding their own representation or where a trustee's costs are payable out of a trust fund. Costs orders are required to identify the intended basis of quantification. Of course, costs which have been unreasonably incurred or which are unreasonable in amount will not be awarded. Under Rule 44.42, CPR, when assessing on the standard basis, the court only allows costs which are proportionate. There is a presumption in favor of the paying party when there is disagreement on whether costs have been reasonably incurred or are proportionate. The indemnity basis, according to Rule 44.43, CPR does not mandate proportionality. There is a presumption in favor of the receiving party. In summary, the two general principles that will guide costs awards are that the costs payable by one party to another are in the discretion of the court, S.51 SCA, and Rule 44.21 CPR, and that the unsuccessful party will be ordered to pay the costs of the successful party. This is encapsulated in the proposition that costs follow the event. While in most cases, obtaining favorable judgment is the successful end to a long process, the entering of judgment by itself does not guarantee the provision of the remedy awarded. If the party at the losing end of the trial refuses to comply with the orders and judgments of the court, then a range of enforcement procedures need to be explored. In the High Court, enforcement is carried out by an independent enforcement officer under the Courts Act 2003. Depending on the subject matter of the order of the court, enforcement can take different forms. For example, for mandating delivery of goods, a warrant must be issued under Section 3 Torts, Interference with Goods Act 1977. Under Rule 83.132 CPR, permission is required to issue a warrant of possession, unless the claim is against trespassers. If a receivership order is made, it has the effect of appointing a responsible person to receive the rents, profits, and monies which are receivable in respect of the judgment debtor's interest in certain property. Noncompliance with an enforcement order leads the person in default to become guilty of contempt of court if it is interpreted as interference with the administration of the law. The term contempt is widely construed, but can mean to disobey a court order which requires a party to do something or refrain from doing something. Contempt of court is usually punitive in nature, but the proceedings do also ensure compliance with the court's orders. Punishment for contempt can be up to 2 years imprisonment. A writ of sequestration can be used where contempt has been proven, and sequestrators are appointed to enter the contemptor's lands and seize their personal property. The court can also lend its enforcement powers to assist with foreign judgments. A foreign judgment at common law can be enforced in England and Wales by claiming the amount of the judgment as a debt within the jurisdiction of the English court. The UK party to international conventions which provide for the direct enforcement of foreign judgments. Relevant legislation which operationalizes these processes can be found in the Administration of Justice Act 1920, Foreign Judgments, Reciprocal Enforcement Act 1933, Judgments Regulation, European Enforcement Orders, Certification and Enforcement of European Enforcement Orders as governed by Council Regulation, EC No. 805/2004.
Woo, that was long.
Thank you for listening to this podcast. Click one of the options on your screen right now for more key content for your SQE preparation. Thank you and see you next time.